This is Michael Lowe. I'm a criminal defense lawyer here in Dallas, Texas. I'm board certified in criminal law. I'm a former prosecutor, and I've been representing folks here in the state of Texas for over 20 years. I get a lot of questions about bonds, and in particular, what I wanted to talk about today is something called an ICE hold, I.C.E. ICE is the Immigration and Customs Enforcement Agency of the federal government, and most people call them immigration. Before we talk about ICE holds, first we should probably talk about how someone normally gets released from jail in the state of Texas on a state case. The way it normally works is you go to jail, you get arraigned, the magistrate in the jail will set a bond, and then a loved one can go to a bonding company and have the bonding company post the bond. They normally would have to pay about 10% to the bonding company for the bonding company to post the bond, or they could just go to the jail and pay cash if they want to. But sometimes folks can't get out of jail, and the reason why they can't get out of jail may have something to do with whether or not they are a citizen of the United States. And this is where the ICE hold comes in. That would be an immigration hold. And what happens with an immigration hold is sometimes the loved one may want to post a bond. They call their bonding company, and then the bonding company may tell them, hey, there's an ICE hold on your loved one. Do you still want to post the bond? And this gets to be a tricky situation where you might want to have a lawyer get involved before you spend your money on a bond. And the reason why you'd want to talk to a lawyer is because what might happen if you post a bond while your loved one has an ICE hold is that they may get released from the state jail or the county jail and get taken to an immigration center where they may get deported. And if they get deported, then they will have a pending criminal case here in the state of Texas until such time as they can return back to the United States, which may be never. It could also impair their ability to ever get any kind of visa or re-entry into the United States. So from my point of view, I think the worst thing that someone could do is when there's an ICE hold, just go ahead and post the bond in state court and then have their loved one released into immigration custody. I think that's probably the worst scenario for everyone involved. And it's also the lowest likelihood that when that person gets to immigration custody that they'll be able to get released from immigration custody. In my experience, the possibility is pretty low that they'll get released from immigration. So what does a lawyer do and what can I do? What is the strategy? What is the game plan in a case like this? Well, the first step is to determine whether or not the case has been filed. You see, what happens is when someone gets arrested in the state of Texas, believe it or not, the police department doesn't file the case right away. So if a case is not filed after a certain amount of time, a lawyer can file a motion called a 17.151 motion. 17.151 refers to the Code of Criminal Procedure that regulates when someone must be released from jail if a case isn't filed. And that amount of time where someone should be released after a 17.151 motion varies depending on the charge that someone is charged with. For example, 17.151 says that on a Class C misdemeanor, C as in Charlie, if someone's been in jail for 5 days and the case has not yet been filed, then the judge has to release that person. If it's a Class B misdemeanor, B as in boy, it's 15 days. If it's a Class A misdemeanor, it's 30 days. And if it's a felony case, then it's 90 days. So it varies depending on the case. Well, what a lawyer could do is a lawyer could file a 17.151 motion, and that's something that I do on the cases where the case isn't filed. And the reason why I do that is because in situations where there is an immigration hold, I have immigration lawyers that I use who I know are very good immigration lawyers. And these are the types of lawyers who actually go to court. They're not the paper pushers that most people encounter when they apply for a visa. These are the lawyers who actually go to immigration court and litigate removal proceedings and really fight with the federal government, much like I do in state court and federal court on criminal cases. So when somebody gets released on a 17-151 motion and goes to federal immigration custody and has a good immigration lawyer, in my experience, the probability of that person getting a bond on their ICE hold in immigration court is very high. And the reason why it's high is because the immigration judge will know that the state case hasn't been filed. And the immigration judge may presume that the state is not really that interested in prosecuting the case to begin with. And in my experience, a lot of those cases, the immigration judge will go ahead and release the person. And so that is a good strategy when the case is not filed. But a lot of times these cases do get filed. And they get filed before I can file a 17-151, or they get filed before I ever get hired on the case. Well, what do I do if somebody has an ICE hold? Well, first of all, I tell the family, don't post a bond, because we don't want that person to be released into immigration custody. If that happens, the scenario I described is likely to happen before. So, they're probably going to get deported. There's going to be a pending case. They won't get any back time credit for the time that they served in immigration custody. So it's a bad scenario. In the rare occasions where that has happened, it is possible to bring them back, but there's a process. It takes quite a while. It's called a bench warrant, and I have been able to negotiate bench warrants with the federal authorities to bring people back, but that is not something you want your criminal defense lawyer to have to do, because the federal authorities don't always have to cooperate with the state authorities, and so they don't always do that. So the best thing to do in that case is, if the case has been filed and I cannot file a 17-151 motion, is to push the case to trial. And the reason why I do that is because in these cases, if somebody's in jail, then the state is under the gun to be ready for trial to prove their case. And if the state is under the gun, they may not have their lab result ready for a blood test or some other forensic test. They may not be ready to bring their witnesses to court. So it's always a good idea to put pressure on the state. And so what I'll do is I'll set the case for trial as soon as I possibly can. Sometimes on the day of trial, the state may dismiss the case because they're not ready. Sometimes the state may be ready, but may want to work some kind of deal out at the last second. The other thing to do, if a case gets filed, is to have an immigration lawyer who can explain what might happen if someone were to take a plea bargain, what might happen as far as immigration consequences. And that's why it's important to have both a good criminal defense lawyer and a qualified immigration lawyer. A lot of times folks will ask me questions about, well, why can't I just hire a lawyer who does everything? And the way I explain it to people is it's a lot like a doctor. So if your kid is sick, you're going to want to take your kid to a pediatrician. A pediatrician is a doctor who specializes in sick children. If you're an adult and your appendix hurts and you need to have surgery on your appendix, you're not going to hire a pediatrician to take your appendix out because they're not trained to do that. You're going to hire a surgeon who's trained to take the appendix out. So immigration law is very different from criminal law. The rules are different. It's a completely different realm. So I don't do immigration law, but I do work with really qualified immigration attorneys who know what they're doing and know how to get people out of jail, and also be able to advise people on what it is the right thing to do in their case. So that's all I really wanted to talk about right now. Basically, to summarize, if the case isn't filed, you really want to try to get the 17-151 motion filed, get the loved one released from jail, from county jail, into immigration custody, and then have an immigration lawyer get a bond, which it is very likely they'll get a bond at that point. If the case is filed, then what you want to do is push the case to trial and hire an immigration lawyer as well as a criminal defense lawyer to work out some sort of plea bargain where your loved one can remain in the United States or re-enter the United States at a later date, or actually go to trial and get a not guilty so that they can remain in the United States. So that's the way I handle ICE holds. People ask me about this all the time. And, I think it's a solution that has worked really well for me over the last 20 years. Thank you very much for watching this video.